Afternoon. I'm Wendy DeVozo. I'm attorney for defendant Donald Blankenship, and I'm here with Mr. Blankenship.
Okay, thank you. I did not have Mr. Blankenship as represented. Are you making your appearance here today on his behalf?
Yes, Your Honor, I am. I was just retained, and we've actually filed a motion to set aside the default, but I don't think the court even has it yet.
Okay, let me, we've got one other party here. Let me see if this is Ms. Blankenship. So just hold on for 1 second.
Certainly.
Hello.
Hello, can you tell me your name, please?
Dorothy Blankenship.
Okay. All right, so we'll go on the record in Blankenship versus Blankenship. This is file number 2514710. The record should reflect that both the parties are present by Zoom video. And counsel, again, if you can put your appearance on for the record, please.
Yes, Your Honor. Good afternoon. Wendy DeVozo, appearing on behalf of the defendant husband, Donald Blankenship. And Your Honor, my P number is 54496. I'm out of Cadillac, Michigan.
Okay, thank you.
And all right, guys, buckle up because this courtroom just turned into a battlefield. Attorney Wendy DeVozo steps up, fierce and focused, representing defendant Donald Blankenship. She's just been retained, and things are already heating up. The judge wastes no time confirming appearances as both parties connect via Zoom. Across the screen appears Dorothy Blankenship, calm but ready for war. The stage is set for what's about to become a verbal crossfire over money, trust, and betrayal in a long, crumbling marriage.
This was set today for entry of a judgment of divorce by default. And Ms. DeVozo, can you just make a record of how you want to proceed today?
Yes, Your Honor. We're asking the court to actually dismiss the motion for entry of default judgment. First and foremost, the plaintiff did not serve a proposed judgment of divorce on Mr. Blankenship according to the court rule 3.210B4A. But in fact, her motion says that she did. So we have no idea what she's asking the court to accept, for starters. Secondly, I was just retained, and I've filed, or on its way to the court is a motion to set aside the default, the filing fee, and a response to today's motion, as well as my appearance. We are asking that the court set aside the default. The parties were actually working together and in fact had ironed out some terms, and Mr. Blankenship did prepare, and I'm going to use the word file in quotes.
DeVozo comes out swinging. She demands the court dismiss the default judgment entirely. Her claim? The plaintiff never properly served the proposed divorce papers. She argues Donald never even got to defend himself, despite mailing his response back in April. And this isn't just paperwork, this is a man fighting for his future. DeVozo insists the default should be thrown out, that both sides had reached agreements, and that Donald, disabled and vulnerable, deserves his fair share. The courtroom tension spikes. You can feel the challenge in her voice.
Filed an answer with Ms. Blankenship, and I've got a receipt dated April 1st, 2025, where he mailed that to her and had shared that with her. But meanwhile, she went to the court and got a default. So I think that if the court hears the motion, there's good cause to show that the default should be set aside. Additionally, this is a long-term marriage. Mr. Blankenship is disabled, and he is going to need his fair share of the marital estate. And so there are some important issues to decide here. So I know my motion's not before the court, but as far as request for a default judgment today, we're asking that that be dismissed for all of the above reasons.
All right, thank you. Ms. Blankenship, what is your position on this?
I would like to get this done. He may have mailed that on April 1st, but he did not serve me. I did not pick that up until the 14th. So well over the allotted time. as far as that. And as far as, yes, most of the stuff we have agreed on, we have come to an agreement upon. The only thing that I am asking is regarding the equity of the home. We refinanced the home in 2022. At that time, Donald and myself both got half of the equity. He took the entire equity, had it placed into an account that was in his name only that I was not aware of.
Then boom, Dorothy fires back. I want this done, she says, frustration all over her face. She claims Donald mailed his response too late and hid money from her. She paints a picture of deception, accusing him of keeping the house equity, misusing funds, and dumping the aftermath on her shoulders. She's angry, raw, and determined. Ice damage, pine beetle problems, piles of trash, it's all on the table now. Dorothy isn't just defending herself. She's demanding justice for what she calls the mess he left behind.
He had to then re-give me the half back that we agreed upon. So the equity has already been split. It was split in January of 2022 when we refinanced the home. There's also a matter of, we had ice damage in February just before filing, which Don took it upon himself, even though he wasn't staying here, or fixed the roof, to file a claim against the homeowner's insurance, which will leave me to fix the roof because they denied the claim, will leave me to fix the entire front portion of the house, the walls and the floor in the bedroom. So as far as equity, I don't think it should be split 50-50 like he is saying. I think that the equity has already been taken out of the home. And I'm left with a lot of cleanup. We cut 10 acres worth of pine due to the pine beetle, and he received half of that money as well as that myself. And then also he has significant amount of garbage on the property that will take multiple dumpsters to clean up, which I sent to you and him in evidence.
Okay.
He didn't believe that my divorce papers, and he stated to me that I did not believe that I filed for divorce, and that was his reasoning to me for not responding in a timely manner.
Okay. All right. Number one, Ms. Blankenship, just so you're aware, I'm not making any decisions today about how the property should be divided up.
Dorothy doesn't stop there. She dives deep, accusing Donald of avoiding responsibility and leaving her with mounting bills and chaos. The equity fight becomes personal. She claims he took the money, left her the damage, and even cashed in on property sales. Her words slice through the silence. I'm left cleaning up his garbage. The courtroom atmosphere thickens, accusations pile high. It's no longer just a divorce. It's a war of survival, one side begging for fairness, the other fighting to be heard.
And certainly the court will take into account your side of things, just as I will Mr. Blankenship's side of things. In terms of moving forward today, under the law, the court is required to make sure that any judgment that's entered in a divorce case is fair and equitable. So even if the default were to go forward, any judgment that was entered, the court would still be required to make that consideration. So
Correct.
In light of that, in light of the issues that both sides have raised here today, and without making a decision about whether the court will or won't set aside the default yet, the court cannot enter a judgment of divorce today, in my view. So, Ms. DeVozo, did you get a hearing date already for my office?
We're working on it. We did make an attempt to, but we haven't heard back from the court. So we'll continue to get that, to work on that and get the soonest date we can, so we can get this moving forward. I don't think anybody wants to spend a lot of needless time and money, but you know, here we are. So we'll try to move it forward quickly.
Well, Your Honor, I am stuck paying every bill because
The judge steps in calm but firm. He reminds both sides this isn't about revenge, but about fairness. Even with a default, he warns, the court must ensure equity. But Dorothy isn't cooling down. She says Donald hasn't paid a single bill since February, not $1. Every expense, every burden, she claims, fell on her shoulders. $600 electric bills, car insurance, house payments, all hers. Her voice cracks under the pressure, but her anger is still burning bright. The courtroom feels like it's seconds away from exploding.
Donald has not paid one bill in this home, not a dollar towards anything in this home since February of this year. So I have been left to pay every single bill in this home. He has left all of his responsibilities onto me, leaving me with $600 electric bills and the house payment and his phone bill up until this last month, his car insurance up until the last month and everything else. So he has took every dollar of income that he has and used it for himself,
Okay.
which has
Well,
allowed him to retain the attorney, apparently.
Okay. If all of that is true, then that's certainly going to make a difference in how things
Yeah.
are divided up. So, the only thing I would say, Ms. Blankenship, is you may want to consider retaining your own counsel.
I guess I will have to. That's why I was trying to move forward. We do still agree on everything. I'm not sure why he retained a lawyer other than the house. That's the only thing. He wants half of the house, and I was leaving that in your decision to make. He has also assets that he did not report, even when he responded. His drag car that he claims is a 1963 split window vet worth considerable amount of money, not the $2,000 he claimed. He also has a 1985 square to body pickup truck that it is his friend Joe Steele's residence or his place of work at Extreme Automotive, as well as a 72 soft top Nova.
Apparently, he can afford an attorney. She snaps and that line hits like a hammer. The judge listens, taking notes as the chaos unfolds. Dorothy presses harder, revealing hidden assets, vintage cars, secret accounts, and property he allegedly sold off during the divorce. A 1963 Corvette, a 1972 Nova, a 1985 pickup, it's a treasure chest of unreported wealth. He lied about everything, she declares. The judge keeps his composure, but the audience can feel it. This divorce isn't ending quietly.
He's also removed items from the property since the divorce, and he has sold items since the divorce.
Your Honor.
Well, look, I'm not making any decisions today, Ms. Blankenship. I understand that's your position. As I sit here, I have no idea what has gone on so far. So all of that's going to have to be hashed out either by agreement of the parties or through court proceedings. So again, Ms. Blankenship, it may be in your best interest to consult with an attorney here so that you can make sure that your rights are protected. As it is, we're going to proceed, Ms. DeVozo, with your motion to set aside the default. The court will make a ruling on that once we have a hearing for it. I am going to ask that you file, if you haven't already, a written appearance for the court file in addition to your appearance on the record here today. And we'll go forward with that motion once that's set. And Ms. Blankenship, you will receive notice of the date and time of that. And that's how we'll proceed.
Yeah, that sounds good, Your Honor. And I've done all of that. I've filed a written appearance, or it's on its way to the court. So I'll follow up with a hearing date then.
Okay. All right. Thank you. That's all for this hearing today. And both sides are free to disconnect at this time.
Thank you. Have a good day.
Finally, the verdict for today, no judgment yet. The judge halts everything, demanding proper hearings and full evidence. He advises Dorothy to get her own lawyer and tells Wendy DeVos to file her paperwork. The session closes with tension still boiling. The Blankenships log off, but nothing's resolved. This isn't the end. It's just the calm before the next storm. Stay tuned, because this courtroom drama is far from over. Like, subscribe, and come back for part 2. The battle for the Blankenship estate has only begun.